Hi folks, today I want to talk about the value of ICBC and other British Columbia personal injury claims. And what I'm talking about here today are tort claims, claims for compensation in the civil courts when somebody's injured you either through carelessness or intentionally. When you have the right to sue somebody for your injuries, what is your case worth? The goal of the civil personal injury lawsuit system is to compensate those injured through the actions of others, through the careless or intentional actions of others, to bring those people back to the position they would have been in had they not been injured. And when bringing these lawsuits, there's certain common areas that are covered in most claims. And what I want to talk about today are the most common heads of damages or areas of compensation that are addressed in these British Columbia personal injury lawsuits. The first is something that lawyers call special damages. These are out-of-pocket expenses, money that's been spent and would not have otherwise been spent if you had not been injured. And so what I'm talking about here are things like expenses for therapies, expenses for medications, expenses for mileage driving to the doctor, back from the doctor, parking related to that, all of the money that you would have spent or that you've spent treating your injuries that you wouldn't have spent if you weren't injured in the first place. Those are special damages. So long as your special damages are reasonable, they likely will be compensated. You're likely going to have awards in damages provided to you to pay you back for those types of expenses in these lawsuits. Another very typical head of damage is past loss of income. If you're injured and you can't work, you have to take some time off work to recuperate, to rehabilitate from your injuries, and if that time away from work is reasonable, you could claim damages for your past loss of income. If you have to stay off work for an extended period of time, or perhaps you're self-employed and you can't take advantage of all the opportunities that are coming your way, you could also seek compensation for those lost opportunities. And again, it just comes down to whether you could prove the money you would have earned if you took advantage of those opportunities, and if it was reasonable for you not to take advantage of those. And if you could prove that, you can get money for your past loss of income. Now, not all personal injuries get better. Some of them, some of these injuries remain symptomatic by the time of settlement or by the time of trial. And if there's persuasive evidence that injuries are going to linger into the future, be it for a defined period of time or indefinitely, then the courts also award future losses. So if the medical evidence establishes in your personal injury claim that you're not going to get better and that you're going to need certain therapies in the future, certain medications in the future, you have to be able to put a reasonable dollar figure on those types of expenses, on those types of therapies that you're going to have, and you can be compensated for the cost of future care. And when speaking of the future, the same holds true for wage loss. If your injuries don't fully recover, and there's a real possibility, and that's the test in British Columbia for these future wage loss claims, if there's a real possibility that your injuries are going to cause a wage loss in the future, then the courts do compensate that loss. Or if you're thinking of settling, you're going to need to think of what a realistic value of your future income loss will be. Now, the BC courts, they don't call it future wage loss or future income loss. They like to call it diminished earning capacity. And the theory is as follows. Everybody has a capital asset, and that capital asset is their ability to earn a living. If that person has been injured and the injuries are going to linger in the future, perhaps they're going to be permanent, that capital asset, that ability to earn a living, has been compromised. And so long as there's a real possibility that there's going to be some sort of loss of earnings in the future, then courts will value that and they'll assess damages for diminished earning capacity. And so be it going to trial or be it settlement, you're going to want to think about what the realistic future losses on your ability to earn an income are in the event of lingering injuries. I've covered past out-of-pocket expenses, special damages. I've covered cost of future care, and I've covered past loss of income and future loss of income. And that leads me to the fifth and perhaps the most common head of damage in these personal injury claims, and that's what lawyers like to call non-pecuniary damages, and that means non-monetary damages. And generally when I say non-pecuniary damages, what people think about is pain and suffering, loss of enjoyment of life. If you've been injured through the acts of somebody else, be it a broken arm, a broken leg, soft tissue injuries, brain injury, whatever the injury is, so long as it's a real injury, you're entitled to claim for non-pecuniary damages. Now, valuing that is really much more of an art than a science. If you were to phone around and ask a dozen lawyers to give you a specific dollar of how much your non-pecuniary damages are worth, and if the lawyers were willing to quote a dollar figure, none of them would probably match up, or very few of them would match up. And the reason for that is the only way to find out exactly what your non-pecuniary damages are worth to the dollar is to hear it from a judge after a trial. But appreciating that you're watching this video to get some advice about the value of your claim, if you're thinking of settlement, or even if you are thinking of bringing your claim to trial, the best way to think about valuing it is in ranges of damages. There's going to be a range of potential results, all which are perfectly fine in the eyes of the law. And what you want to find out is what range of damages is appropriate for your claim for non-pecuniary loss. And the best way to find that out is once you figure out exactly what your injuries are, once you figure out exactly what the diagnosis is, what was caused by this wrongful act, and once you figure out what the future impact of those injuries are going to be, hit the books. You're going to want to look at cases dealing with similar injuries. You're going to want to look for people generally in your same age category with the same injuries or similar injuries with a similar result. So if you've had surgery, you're going to want to look at other cases where people had surgical intervention. If you have a poor prognosis, you're going to want to look at other cases where the plaintiffs had a poor prognosis. And you're going to want to read half a dozen, 2 dozen of these cases. And from there, what you're going to do is find a general range of acceptable damages. You're going to see what the British Columbia courts are awarding for similar injuries. And from there, you could figure out what the realistic low end and the realistic high end of your non-pecuniary damages is going to be. From there, you could figure out what you're willing to settle for, or if you're not getting something that you consider sensible on the table, whether the risks and rewards of trial make it worthwhile to move forward. Pain and suffering, again, it is much more of an art than a science, and it takes some time getting familiar with these types of injuries to get a good sort of a ballpark range of what any claim for pain and suffering is worth. But with some time, with some dedication, and with some specific knowledge about what your injuries are and what the future holds for them, you could figure out a realistic range. And you know, one place you could turn is my website. I've taken most of the cases from the British Columbia Superior Courts over the past few years and summarized them, and I've categorized them by injuries. And if you're not finding similar cases there, another wonderful, wonderful resource is a website called Canley, and that's CANLII.org, Canley.org. And this is a Canadian website. It's a free legal database, and it has cases from all across Canada, but you're going to want to look in your jurisdiction first. So if you're a British Columbia accident victim, you're going to want to look at British Columbia cases and see how British Columbia courts are valuing similar injuries. And from there, you could come up with a sensible range of damages for your non-pecuniary loss, and of course the other heads of damages. This has been just a very brief introduction. There's other heads of damages that come into play largely with more complex personal injury claims, more serious personal injury claims, but the 5 I've covered today are the most common claims for damages that comes up in these types of cases. As always, I'm happy to answer any questions any of you may have about what I've covered today or about other assessments of damages in personal injury claims. Thanks for visiting, folks. If any of you do have questions, you could reach me toll-free. Number is 1-800-663-6299. Thank you.